SJC-11921, Commonwealth v. Derek Epps.
Good morning, Mr. Hirsch. Just give us a moment and we'll get you started.
If it please the court, Mr. Chief Justice, David Hirsch representing Mr. Epps. Mr. Epps was convicted on the basis of questionable evidence, at least in part because counsel didn't find an expert who would help him challenge that evidence. As a result,
Before you get there, and before you get all wound up, what was the Commonwealth's theory as to when this event occurred, when the assault occurred?
I'm not sure I'm following Your Honor's question.
In this particular case, when precisely, I mean, I guess that there's no dispute, I gather, that when the older sister said that she had fallen,
Yes.
Fletcher was there and with the defendant. Is
Yes.
that, so it didn't occur at that moment because Fletcher was with them. Was that sort of the way trial played out, that no one claimed it happened at that moment?
Nobody claimed it happened at that moment. I think the court is asking about the possibility that Sarah Como was the assailant in this case.
No,
Well,
just-
there is that. I'm just trying to figure out when, I mean, he's playing Madden football with Fletch.
Right.
And I'm trying to understand when the Commonwealth claimed was the event which caused the severe injury.
Mr. O'Sullivan, my brother may contradict me on this. To the best of my recollection, they did not state a specific time when it happened. Nobody contested the fact that the child was found on the ground in bad shape at the time that the older sister found her there.
But it must have been before Fletcher arrived, right? Because once he was there, he didn't leave again, right?
That if one believes that Mr. Fletcher was not involved in any of this, that is true.
Was that part of the Commonwealth's
No.
theory?
No one claimed this. But again, I think your honors are pointing out some gaps in the Commonwealth's theory. They're saying that, yes, this happened, but there is no specificity about when.
Was there a range of time within which the injury may have occurred, at least according to expert testimony?
According to our expert, Dr. Scheller, the possibility of a lucid interval made it possible that it happened anywhere between.
I thought that's also what the Commonwealth's experts said, that there was a possibility of an interval of lucidity. Isn't that what the Commonwealth's expert also said?
Well, kind of, because what...
Kind of?
Yes, kind of, because first of all, they said, yes, it's possible that there would be a remaining consciousness, but that the child would not be able to function normally, would not speak normally, would not present normally.
But what about at trial? What was the range of time in which the injury could have occurred?
At trial, I believe Dr. Wilson testified that there would not have been a lucid interval. And again, I have two cases today. There's a possibility I'm getting the facts mixed up, but that's my recollection.
Okay.
And did Delilah testify? I guess she did not.
She was a 4-year-old child when this happened.
But she didn't testify to how her sister was acting before she fell, so there was no information as to how she was acting before she fell.
There was testimony from various people, from Sarah Como, from Mr. Fletcher, from Mr. Epps, well, not testimony, but his recorded statements to the police that Delilah, although had vomited earlier that morning, that was Mr. Epps' statement, that this was after she had fallen off.
Not Delilah, Cindy.
Cindy, I'm sorry, that Cindy had fallen off the stool at breakfast and then had vomited, and this is consistent with the defense theory.
If we agree with you, does that mean that whenever the Commonwealth presents an expert witness on any subject, the defendant must also present an opposing expert.
Not at all, not at all. That's Harrington versus Richter. There are only certain cases in which cross-examination isn't going to do the job, and in those cases, expert testimony is necessary. Here, it's even possible that if trial counsel knew his stuff about shaken baby syndrome, he might have been able to meet that Harrington versus Richter standard. He might have been able to cross-examine Dr. Wilson sufficiently so that an expert wasn't needed. Doubtful, but possible. But here, his cross-examination was limited to, well, doesn't Dr. Plunkett say that this could be caused by a short fall? Dr. Wilson said no. That was the end of it. That was the entirety of it. So this is certainly not one of those cases where cross-examination can take the place of the expert. Rather, this is the kind of case talked about in both Harrington and Hinton versus Alabama, where cross-examination is not going to be sufficient, where the expert is required.
Also, may I ask you what you think trial counsel was supposed to do? He consulted with Dr. Sussman. Do I have the cases right? Is this the one? Dr. Sussman, who said it couldn't have happened the way your client said it happened. And he also told him that the witness that he proposed to rely on could be effectively challenged because his opinions had been discredited in some other case. So what was he supposed to do in that situation?
Look elsewhere. This is, there are two possibilities in this case, Your Honor. Either there were other experts available, people like Dr. Lietzma, various other experts whom we have cited in the briefs. Either they were available in 2007, in which case there was no excuse for trial counsel not to find them.
Okay, so in response to Justice Spina, so we should have a two-expert rule then. If
No.
at first you don't succeed, try again.
No, not necessarily. And case law makes it clear that it's not a point of expert shopping. But when there is a split in the medical community or any scientific community, it is irresponsible not to, and the Commonwealth is presenting one side of that split, it is irresponsible not to do the work necessary to challenge it with the other side, whether through cross-examination or an expert. And that's what happened here.
Now, this trial was 2007.
Yes.
And I have not seen the transcript of Dr. Schuller's testimony. All I have is a reference to it in the Commonwealth's brief. It says that in 2013, I guess, when he was testifying, just 5% of the relevant medical professionals would have shared his view.
That was his rough estimate.
5% in 2013.
That was his rough estimate. But the issue is,
So whenever there's a controversy, even if it's 1% or just someone at Stanford or someplace.
no, I think that's the difference between the knowledge base that trial counsel had and the knowledge base he should have. All he knew about was Dr. Plunkett. And Dr. Sussman was able to tell him, Plunkett is a little dubious. But there were other experts, and there was sufficient acceptance by the courts of the attacks on shaken baby syndrome in existence in 2007. He was ineffective for not using that. If it wasn't accepted by the courts in 2007, then it's newly, I use the phrase newly discovered evidence, as in Sullivan, I probably should have used the phrase newly available evidence, because newly used by the courts.
Well, if it's newly available evidence, and let's assume for the moment that's the argument, doesn't the judge have some role? In assessing the credibility of it and the strength of it?
No,
No, even if it's newly available,
Yes.
Even if it's a complete quack?
No, because here, and this is the part I left out in my answer to Justice Cordy, is there was a finding by the hearing judge that Dr. Scheller was reliable. It was kind of a backwards finding. He said
But he found him incredible. He found his testimony incredible.
he found him qualified and sufficiently reliable such that questioning could be could be continued. When I asked, can Dr. Scheller be qualified as an expert, the hearing judge said, well, inasmuch as I don't grant objections, yes, he is he is an expert. That's the difference. If we bring up some quack,
But it's a motion for new trial. Of course, I mean, it just seems to me it stands to reason that the judge is going to let the person testify and then make a judgment, right?
But that's not what occurred here. The judge said, as long as I don't object, he's a qualified expert. Meanwhile, I think I'm getting a little off the topic here. The issue is not whether there would just be one person who one quack who goes along with this theory. The issue is, at least at 2013, there was a well-developed body of scientific evidence, peer-reviewed journals, experts in the field, disagreeing with this entire theory. In fact, even among the proponents,
Is that our rule? Is that what our rule should be, that if there is a divergence in opinion in the medical community, then a defense lawyer must call an opposing expert witness if the Commonwealth?
that's very fact-dependent, Your Honor. In other words, in certain cases, the courts have held, well, that wasn't the major issue, so it was unnecessary. If, in this case, there had really been a defense that Sarah Como did it, perhaps it would have been unnecessary to challenge the theory. But, first of all, trial counsel said, first, well, Sarah Como was my theory. Then he said, well, if I could have found a qualified expert to challenge shaken baby syndrome, I would have hired him. Then he said, I decided not to bring up Ms. Como as the possible assailant until closing argument because I was terribly worried about the gap in time. Then he said, well, after Celeste Wilson testified and said there could have been some interval in which the child survived, in which the child remained conscious after the incident, that's when he finally decided to bring this up in closing argument. This was improvisation. This was a defense on the fly. It was not strategy. It was a last-minute, last-ditch effort.
Put aside for a moment whether counsel was ineffective. What do you say we know now that we did not know then, which potentially could have influenced the jury's decision?
We did, then being 2007,
7.
Yeah.
we now know that there can be a completely lucid interval for a long time. We now know that there is a large body of evidence, largely biomechanical, but other evidence, showing that shaking does not produce enough force to create the kind of injuries that Cindy suffered. We now know that there is, that a short fall can produce these kind of injuries. Indeed, even in the 2009 paper written on behalf of the AAP by Dr. Christian, she said, yes, it is possible. These are vast.
This is the one that said it's 1 in a million?
No, that's Chadwick, and Chadwick is interesting because Chadwick's article is as if, say, I had the thesis that all SJC justices are under 6 feet tall. Well, Justice Cordy is well over 6 feet tall, so
I used to be.
you still
time
are.
ago.
So obviously, the answer, according to Dr. Chadwick and Trenches and similar doctors, is obviously Justice Cordy is not a member of the SJC. In other words, when you remove all the people you don't want to include in the survey at the beginning, when you include remove all the people who say that this was shaken baby syndrome, or at least 99% of them, because you don't believe it, it's obvious what results you're going to get, and they're not going to be very scientific.
Let me ask you, you say that one of the things we know is that shaking does not produce enough force to cause the injuries. I thought that was wrong. I thought what we know now is that those injuries could be caused by shaking or other things.
Other things, yes. Shaking can be a part of it, but not alone without the impact injury, without the slamming or something of the kind. So obviously this remains a matter in controversy. It's not for either lawyer here, or probably not for the court, to say which is true. It's enough to say this is deeply contested, and it wasn't contested at trial. The main issue at trial was not tried.
If you go back, I'm sorry, you mentioned another author's name when I mentioned Chadwick, and the name of that author was?
I can't pronounce it. Trench with an S at the end of it. And there are several others quoted in the brief, cited in the brief.
This child was over 2, if I recall
Yes.
correctly. And much of the, at least I thought, that much of the theory and the literature is about infants. So does it make a difference that she's over 2?
It depends. Some experts will say, and I don't remember which expert in these 2 cases said that there's less likely to be injury with a 2-year-old. Also, the evidence on both sides is largely dominated by infant studies. Further, Dr. Plunkett dealt with children who were toddlers as well as infants. And Dr. Plunkett, I believe, has been rehabilitated by many of the sources we have cited.
But is that an issue in this case that you are raising, that's another piece of this, that this is not an infant, and therefore, even more so, it should have been explored? I
don't recall if it's in this case.
Well, the other child was an
Right.
infant.
And I did raise in this case that most experts say that the vast majority of shaken baby cases occur when the child is 3 to 8 months old, which would, incidentally, I think it's not a major part of our case, but does once again point away from shaken baby syndrome.
Did this child, last question, did this child have any, is there evidence of neck injuries of this child?
No, there may have been a little bit of soreness in the neck. Again, I'm trying to remember which case is which, but there were not the kind of neck injuries one would have expected from shaking, not the kind of severe injury that the experts talk about.
Those back injuries, though, or something.
Soft tissue,
Right below.
Right, and Dr. Scheller says that these kind of injuries can be caused both accidentally and traumatic, or be inflicted. Indeed, the most important fact to him was that the child had fallen down the stairs, and that can cause extra trauma on all parts of the back, all parts of the body, because of the repeated trauma as you go step by step by step.
I'm sorry, the stair falling, who testified to that?
Well, in his statement to the police, which was admitted into testimony, Mr. Epps said that. The key is whether Mr. Epps' statement was credible.
That she fell down the stairs before or after she fell off the stool?
After.
After. She fell off the stool and then
Right.
fell down the
And
stairs.
this is a child who, according to her mother as well, was clumsy, ran into things all the time, made this kind of mistake all the time.
Okay, although she is 2 years old.
Perhaps most do. I'm not a parent.
Okay, thank you.
Thank you.
Good morning. May it please the court, David O'Sullivan for the Commonwealth. I'd like to start by clarifying three factual issues, beginning with Justice Gantz's question about the Commonwealth's theory about the timing of the injury. The Commonwealth's medical evidence, Dr. Celeste Wilson's testimony, was nonspecific as to the timing. Her testimony was that it was difficult to time injuries of this kind. The first line of the Commonwealth's closing refers back to the focused cross-examination of Mr. Fletcher, in which Attorney McGuire, I would say skillfully, narrowed down the time that Mr. Epps was alone with Cindy upstairs after Delilah had called down from upstairs, down to 2 minutes based on the number of downs that Mr. Fletcher had played in his absence. So that the first line refers to that 2 minutes or 5 minutes or 4.5 hours, clearly referring to the whole morning. You can measure the time however you want, but ladies and gentlemen, I would suggest it doesn't make a difference. It's all time that the defendant, Derek Epps, was alone with Cindy and her big sister on October 9th,
But
2004.
did Celeste Wilson testify that, about lucid intervals?
She did, Your Honor. She testified on direct examination as to the possibility of a lucid interval. And further on cross-examination, that was developed by Attorney McGuire.
I mean, maybe I'm, quibbling, I don't know, but I'm recalling from the briefs that it was a reluctant agreeing. I mean, that maybe it's possible, or was she firmly testified that, yes, this is definitely a piece of this syndrome?
Yeah, she testified it was possible that there'd be a lucid interval in which Cindy would not be expected to be 100%, but could be walking and talking, or would not expected to be walking and talking, would not expected to be 100%, but in which she would not appear to be manifesting as she was upon finding her upstairs.
Hey, I'm sorry,
not
I'm
walking
sorry,
and
I'm sorry, you need to clarify what that means. It means that she, I mean, of course, she would not be as she was when she was unconscious, but did she testify that it would be such that a parent would not notice? Or that it would not be
Yes.
clear that, I mean, she'd be talking and acting as if she was simply a sick child, but not a desperately sick child?
Yeah, she testified that it was possible that she would be presenting in a way, not as she ultimately presented, but and in a way that a person may not detect that she was ultimately, that she had been injured for some time after the infliction of the actual injury. So that was definitely in evidence in direct exam and developed on cross-examination. Now, the other,
Is there any testimony as to the length of that lucid interval?
there wasn't testimony as to the specific length of that lucid interval, but this highlights the wisdom of Attorney McGuire in presenting that what was initially a reasonable doubt defense, which he skillfully developed into a third-party culprit defense. He established, and I say forcefully argued, that it was Sarah Camo who was with the Cindy for 10 to 15 minutes alone upstairs in an angry state prior to her presentation with those injuries.
And Delilah wasn't with her?
Delilah was up there as well. And Mr. Epps's testimony was that after she had brought Cindy downstairs, or his testimony, his statement was he had brought her downstairs and she had been saying, my head hurts, but was clearly sentient and speaking at that time. So it was a focused argument that she was the person who was alone for the longest time with Delilah for the longest time with Cindy. The two other factual issues I'd like to talk about are Mr. Epps's contention to police was that she fell downstairs before, not after the stool incident. And with respect to the injuries to the neck, there was testimony.
That's what he said before the stool incident?
Yes, 8:30 in the morning with respect to the fall down 3 treads of stairs. And after that was the fall off the stool at roughly 11:30 in the morning. So the last factual issue would be the injuries to her neck, and there were injuries to her neck, swelling specifically in her neck tissues. I'd like to launch right into the ineffective assistance claim.
Before you do that, I'm having a little trouble with the logical dissonance in the judge's ruling that it's not newly discovered, but it's not ineffective not to have raised it. So could you help me understand how the judge reconciles
Well,
that?
on the one hand, the judge found that it was not newly discovered. In fact, it was discovered. These dissenting views were there for the taking in 2007. And in fact, Attorney McGuire learned of them, read literature on them, consulted Dr. Sussman about them, consulted other attorneys who had consulted with opponents to shaken baby syndrome. So it
Is
wasn't.
there anybody that he talked to that hadn't talked to anybody other than Dr. Plunkett?
Well, he spoke to Dr. Plunkett. He spoke to an attorney who had consulted with Dr. Plunkett and ultimately decided not to call
Right,
Dr.
but was
Plunkett
there
in the
anybody
case.
else?
He had also read literature. There's no evidence that he spoke to anyone directly, any of the SBS opponents directly. But I would submit that he did something that is frankly better. He spoke to his chosen expert, who we viewed as impartial and trusted, based on his using him 6 times at least in the past, and he spoke to him about the possibility of launching a defense that challenged the science underlying abusive head trauma shaken baby syndrome. And he learned from Dr. Sussman in the course of that consultation that these scientists represented a small minority and that the vast weight of the authority hewed to the validity of the diagnosis, and that these minority doctors had been attacked by their peers, and their science had been attacked. He also looked at it from a legal perspective, which I would submit is important because you want to learn not only from doctors about the possible validity of the science, but also the testimonial efficacy of that witness for your client. And he spoke to a lawyer who had consulted with Dr. Plunkett and ultimately decided not to call him. And this mostly snaps into focus, or very clearly snaps into focus, when you look at the record the defendant developed in the course of the motion for new trial, in which his own expert, Dr. Scheller, admits that his views are maintained by 5% of the relevant medical professionals, which would leave the other 95% as adhering to the validity of this diagnosis.
But what does that mean, the diagnosis? I mean, there's a difference
Sure.
between a diagnosis designed to determine a course of action by a doctor, that is, for instance, do we bring in DCF and remove custody of a parent based on that diagnosis, versus a diagnosis here which has to be, we have eliminated beyond a reasonable doubt every cause other than intentional assault.
Right. There's certainly a difference between the diagnosis in a general sense and the validity of the medical diagnosis, which is solely based on the triad of symptoms. This is evidence of abusive rather than accidental injury. That's the testimony or the diagnosis in general. Its application in particular cases is often a matter of controversy. Certainly, there's been increased notoriety with respect to that 5% dissenting minority in regards to cases in which this diagnosis has sometimes tragically been misapplied, and been misapplied in the context of a failure to rule out those differential diagnoses, which are a part of any valid diagnosis.
But is it a medical diagnosis for purposes of future treatment, or is it a forensic diagnosis for purposes of a lawsuit?
Well, it is both, essentially, because you would the treatment, there'd be treatment consequences to a ruling that the child was in a house that was abusive or was with a caretaker who was abusive. And there's also obviously a forensic application for that diagnosis in the criminal and civil context.
But in terms of the child in the house, that goes to where the child lives thereafter. Does it really go to the medical treatment? I mean, once this injury happens, this really goes to determining the cause of it, doesn't it, as opposed to the sequelae that come about because of it?
Well, it would certainly inform a doctor's medical treatment of any child if they knew that injuries that they observed on the child were inflicted by a caregiver as opposed to accidentally accidentally sustained. Now, I think it's most important to, when assessing Attorney McGuire's performance, to look at the components that went into his decision when he ultimately decided not to call an expert who espoused the views of this 5% minority. And I would submit that those were pretty solid steps in terms of reading the literature, consulting with an attorney, consulting with his own expert, and learning from other attorneys that partisans against the SBS-AHT diagnosis were not particularly effective witnesses for a client. He could also presume the following. In this case, there was only, and I know this contrasts with other cases, there was only one witness, Dr. Celeste Wilson, on the extent of the injuries. There was only one witness who testified to Cindy's injuries in this case. Counsel could presume that had he noticed an expert in the course of preparing for trial who critiqued the foundations of the science of AHT-SBS, that the Commonwealth would potentially include far more testimony about the natures themselves and about the general acceptance in the relevant scientific communities of this diagnosis. For example, the Commonwealth could have called the treating ophthalmologist, Dr. Carolyn Wu. It could have called the neurosurgeon, which could have been extraordinarily dramatic and damaging testimony to the defendant. This would involve long, drawn-out testimony, potentially about the nature of the injuries and the acceptance of the diagnosis. Instead, he wisely elected to and skillfully developed a third-party culprit defense. Now,
what do you say about your brother's claim that that was an improvisational defense, that it was sort of a last-minute concoction?
Well, I would submit that before trial, Attorney McGuire was asked point blank whether he would mount a third-party culprit defense. And in perhaps what might have been some gamesmanship, perhaps what might have been skirting the edge of his duty of candor to the court, he disclaimed any intention of doing so. And true to form, in his opening, he mounted what was clearly a reasonable doubt defense, reasonable doubt as to who struck the blow, in his words, reasonable doubt as to the possibility it might have been actually accidentally inflicted. I would submit he well knew it was either going to come out on direct examination or cross-examination, the possibility of the lucid interval. That was, as he described it, the missing piece in a third-party culprit defense, which he had preferred to do all along. So I would submit this was not a matter of last-minute improvisation. In fact, I think most tellingly, the defense does not even claim in connection with this appeal that it was manifestly unreasonable to blame Sarah Comeau for these injuries. And he also doesn't point to any way that Attorney McGuire could have done it better. When you look at his performance in this case, I would submit you have an attorney working diligently for his client and exercising his best judgment. And even with the benefit of hindsight, even with the benefit of the record the defendant developed in connection with the motion for a new trial, that I would submit that was a wise choice. Dr. Scheller's testimony and the infirmities that were exposed in cross-examination of that testimony are very telling. Even if in a new trial, Dr. Scheller could have been prepared enough as a witness to not sua sponte offer his philosophical views about whether a normal person would shake a child. Those would presumably come out on cross-examination. And once they did, and his views that a normal person without a violent history would not shake a child, he would be confronted with the fact that the defendant had a violent history, specifically as to this child. There were testimony from 3 separate witnesses about the defendant's prior bad act to this trial. Comeau herself, Gomez, Nika Fontaine, who testified to injuries that I would submit that are way beyond, even if the defendant were a parent, the normal sort of parental discipline that you expect for a 2-year-old child. These catastrophic injuries that Cindy suffered were a difficult obstacle that Attorney McGuire faced in connection with this case. These types of catastrophic injuries are not ones that could result from a shortfall according to the vast weight of medical opinion, and he was wise to offer a third-party culprit defense instead. If there are no further questions, I'd rest on my brief.
Well, I have one. You've spent your time, obviously, focusing on the ineffective assistance of counsel. As I read the amicus brief from the variety of physicians, it seems that there is at least a view, not just the one that Mr. Hirsch has put forward, but or it supports his view that since 2007, yes, there were pieces of this, but that it really this goes to the newly discovered evidence that it really that the weight of the differing opinion and the development of that differing opinion has really been subsequent to this trial.
Subsequent to the trial, but leading up to 2013, when the motion for new trial and the defendant's expert's testimony was that 5% at that point. So to the extent it moved from some lesser percentage to 5% by the time of the motion for new trial, and that's I would submit that is generous, then that is not
What do you
something
think it
that
is today?
whether there are additional doctors who have signed on to that 5% minority viewpoint.
And what's the universe here? 5% of what?
According to Dr. Scheller, it's pediatricians and radiologists. Those are the relevant medical professionals.
Has the science changed in the last 6 years or 7 years?
Well,
or is it just that some people are lining up differently?
I would submit that the major medical bodies, particularly the American Academy of Pediatrics, would not agree that the science has changed. It would agree that what the position paper, the most recent position paper, dealt with was the fact that shaken baby syndrome was being used interchangeably with other types of inflicted injuries, particularly things like shaken slam syndrome or other types of inflicted injuries. And it was a sort of a misnomer to use shaken baby.
So you just changed the name to abusive head trauma and that does it? Is that what you're saying?
Yeah, well, that's what the American Academy of Pediatrics advocates, the use of that broader term where there's more evidence of impact as there was here. There was evidence that the victim's injury are normally seen in falls from over 70 feet or in high-speed car crashes. So that change in nomenclature does not equate to a change in the weight of medical opinion, I would submit, on the validity of this diagnosis.
If going back to this 5%, 5% say what? How do you characterize what this 5% believes versus the 95%?
5% of the relevant medical professionals believe that the triad of symptoms, that is cerebral edema, subdural bleeding, and retinal hemorrhages, cannot be caused solely by shaking. Here we don't have only the traditional triad, though. So this is not a case that in which, for example, there's no history of abuse or anything like that, or there's no skin findings. Here there were fairly significant, I would submit, skin findings that Dr. Celeste Wilson testified are not normally seen in the normal rough and tumble of childhood.
But isn't the more relevant question what percentage of those knowledgeable in the field believe there is a reasonable possibility that such injuries may be caused by an accidental fall?
Well, yes, I think that is, and which brings us to Dr. Scheller's testimony that he could not exclude inflicted injury in this case.
Well, he doesn't have to. It's the jury. The jury is not asking to exclude. The jury is deciding that beyond a reasonable doubt they have excluded. That's a different determination.
True, that is true. But this court's standards obviously look at whether the alleged newly discovered evidence offered in support of a motion for new trial carries a measure of strength in support of the defendant's position. The Commonwealth cites that case, Senna, in its brief, where the evidence offered in support of the motion for new trial didn't ultimately refute the Commonwealth's theory.
But going back to Justice Spina's question and moving it a little bit with mine, has there been a change in the range of medical opinion as to whether an accidental fall is a reasonable possibility that a accidental fall may cause the type of injuries which we had here? Has that changed over time?
Well, the clearest indication we have of that is the position paper that was tacked onto the back of the Commonwealth's brief, where it was a meta-analysis that looked at personal injury databases, other studies and scientific papers, and found that the chances of the triad of injuries that are this catastrophic could be seen in a household fall of less than 4 feet are 1 in 1 million.
Is AAP the Pediatric Association, isn't that right?
Yes, Your Honor.
And isn't the last time they actually took a stand with respect to these issues in 2009, but in the most recent position paper, is that 2013, they didn't, they eliminated their position? So we don't know what they...
No, they haven't withdrawn their, any...
Not withdrawn, but not no longer included. Is that the difference? They didn't say, oh, we don't believe it anymore, but they don't have it as part of their position paper.
Well,
There's
they didn't
something missing.
yeah, they didn't reiterate it. With the
In there?
2009, I mean, I would submit that the 2013 position paper is very clear in supporting the view of the continued validity of the diagnosis in general. And again, this is not to speak to its misapplication in any particular case. Of course, there's increased notoriety of cases in which it's misdiagnosed, oftentimes for failure to rule out a differential diagnosis like a bleeding disorder, like a bone disorder that would, in the normal course, be eliminated as a possibility. No such evidence was offered in support of the motion for new trial here.
All right, thank you.
Thank you.